Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by LiveLaw. We bring to you the latest and in-depth legal coverage, coming to you with a brief of what all happened in the Indian courts today. You have heard about writ petitions and special leave petitions before the Supreme Court. There are also transfer petitions that are filed in the Supreme Court. Normally, transfer petitions are filed for transferring a case from one court of a state to another court of different state. As Supreme Court has the power to transfer these, so far these petitions were heard by a single bench of the Supreme Court. And when notice was issued, then the division bench would hear it. But today Supreme Court has taken a decision that from now onwards, after notice transfer petitions will be listed before the single judge benches as well as division benches. However, fresh transfer petitions will continue to be listed before single benches. An important matter which has come from the Delhi High Court is regarding the Right to Information Act. The issue is whether information relating to recommendations made by Collegium can be disclosed under the RTI Act. The Delhi High Court today, while hearing a batch of 3 pleas, sought response of the Union of India on the same. Calling it an important matter, Justice Pratibha M. Singh asked the Additional Solicitor General Chetan Sharma to seek appropriate instructions and file an affidavit. The RTI applications relate to opinions and other notes of collegium meetings. To tell you more about the 3 pleas, the first one has been filed by Dr. Vinod Surana, seeking information regarding recommendations made between the years 1990 and 1992 by the then Chief Justice of India and Chief Justice of Madras High Court for elevation of his father, P.S. Surana, as a judge of the Madras High Court. The Supreme Court Public Information Officer had denied to disclose the information, so he approached the Central Information Officer, who also denied. He then approached the High Court, which directed the Central Information Officer to hear the application again. But on rehearing also, the information was denied. The other 2 petitions are cross appeals filed in a case where one Dinesh Kumar Mishra in 2008 sought information regarding appointment of 2 judges in Guwahati High Court. This matter will now be heard by Delhi High Court in May. It is important to mention here that a constitutional bench of Supreme Court in the case of CPIO Supreme Court of India versus Subhash Chandra Agarwal has held that the Office of Chief Justice of India is a public authority under the Right to Information Act. You can visit our website for detailed information on this case. The Delhi High Court today sought response of the Union of India and Delhi government on a plea seeking directions to consider enacting the Advocates Protection Act in the national capital. Advocate K.C. Mittal, who was appearing for the Bar Council of Delhi, told Justice Pratibha M. Singh that the lawyers' body and the Coordination Committee of Bar Associations of all district courts were in the process of drafting the Advocates Protection Bill, for which they were also consulting with senior government officials. Taking note of the submission, the court directed the Bar Council of Delhi to file a status report, and the matter has now been listed for May 25th. As you are aware of the killing of Advocate Virendra Kumar earlier this month, other incidents of shooting inside the court premises have also been on the rise. Comment below and tell us about your opinion on the need for an Advocates Protection Bill. The Delhi High Court today sought response of Enforcement Directorate on the bail plea moved by Aam Aadmi Party Communications in Charge Vijay Nair in a money laundering case relating to Delhi's excise policy of 2021-22. The money laundering case arises out of the FIR, which was initially registered by the CBI, where Nair was accused of entering into a criminal conspiracy with other individuals related to the said excise policy. But he was later granted bail by the trial court in October last year. However, he was later taken in custody by the Enforcement Directorate in the money laundering case. Justice Dinesh Kumar Sharma today issued notice on Nair's plea and listed the matter for hearing on May 19th. As you know that Aam Aadmi Party leader and former Deputy Chief Minister of Delhi, Manish Sisodia, was denied bail last week in the case alleging corruption in implementation of excise policy. The probe agency's case is that there were alleged irregularities in framing and implementation of the excise policy for the year 2021-22. The agency has also claimed that there was a conspiracy coordinated by Vijay Nair and other individuals along with South Group to give extraordinary profit margin to wholesalers. According to the agency, Nair was acting on behalf of the Chief Minister and Deputy Chief Minister of Delhi. As you are aware that microblogging platform Twitter has approached the Karnataka High Court questioning and seeking to overturn orders of Government of India under Section 69A of the Information Technology Act, directing Twitter to take down content regarding farmers' protest and alleged mismanagement of COVID-19. The contention raised by Union of India is that Twitter, being a foreign company, cannot avail any remedy of fundamental rights guaranteed under Article 19 and 21 of the Constitution, so their petition before the court is not maintainable. The stand taken by Twitter was that it does not seek any enforcement of right to freedom of speech and expression, but has the Locus Standi under the scheme of IT Act itself, under which when there is a breach, it would give cause of action in their favor. The single judge bench of Justice Krishan S. Dikshit had on Monday asked Twitter to clarify on how laws of other countries, including United States of America, would deal with the aspect of disclosure of reasons by governments while issuing orders to block account for posting objectionable content. The court was informed by Twitter today that Article 3 of the US Constitution confers a constitutional right on foreign national to get access to courts in the United States. Appearing for Twitter, advocate Manu Kulkarni referred to the provisions of Code of Civil Procedure, Section 83 to 87, and defended a foreign entity's right to appear before the Indian courts. The court has now posted the matter for further hearing on April 17th. You can visit our website to read the entire arguments in the matter. Thank you for watching. If you wish to know more details about the cases I mentioned here, please visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share, and subscribe and support us.